Good afternoon, Heidi Oropesa with Florida U Judge, and today I'm in studio with two very good colleagues of mine. I have Brooke Elvington, who's an appellate attorney. She is going to be discussing an issue with us, and she's appearing telephonically. And I also have Donald Harrison, who's a criminal defense attorney, and he practices in the Tampa Bay area. And I first of all want to thank both of you for joining me this afternoon.
Of course, thank you.
I'm glad to be here.
Okay, so we're going to be discussing what's called a Brady rule issue, and that term is derived from a landmark case of the Supreme Court of our country, Brady v. Maryland. And so, Donald, can you just, for the viewers, explain briefly what the Brady rule is?
What Brady stood for is if there is a witness in any case that the government's required to provide them with any evidence that may be favorable to a defendant. We have to put it in context because then what happens, from there we got Giglio, which says if there's a deal made under Giglio, you have to provide the defense with that information. Then it comes 30 years later to Ruiz, and what Ruiz says when it comes to favorable information, that favorable information only has to be shared when it deals with a trial. In Ruiz, she ended up pleading to a charge, and she challenged it under Brady that she wasn't provided the information. The Supreme Court said you only have to provide that information in order to assure a fair trial. A plea does not invoke either Giglio or Brady.
So just real simply, so that the viewers and especially non-lawyers understand that the Brady rule essentially means that if the prosecutor has any exculpatory evidence, they have an obligation to turn that over, and it also includes impeachment evidence, which impeachment, that's the legal term, that means any type of information that the defense can use to impeach possibly the credibility of the witness, yes?
That is yes, only for a trial. They're not obligated to provide it compulsorily unless they set it for trial.
Okay, very well. Okay, so you want to add anything to that, Brooke?
Sure, I would certainly agree that that is what we're talking about in reference to Brady, and I think it is critical, given what we're talking about today, that Brady would incorporate issues related to impeachment. I think we'll further that discussion in a moment, I'm guessing.
Yes. Brooke, and let me ask you a question. You generally do appeals, or do you also do trial work?
I do both. My background is in state and federal litigation. However, several years ago, and by several I mean I think almost 10 now, I began to focus my practice almost exclusively on criminal and civil appellate matters, with an emphasis on criminal. Okay,
so I'm going to go ahead and present a fact pattern, a hypothetical, as what we got when we were in law school, and then I want both of you to comment, weigh in, discuss any issues with this fact pattern. So here's the fact pattern. Prosecutor A charges defendant with a felony, and defendant goes to trial. Prosecutor A presents a witness against the defendant who has a loved one who had also been prosecuted by that office by Prosecutor B, and the loved one, after trial, received a significant prison sentence. The defendant, prosecuted by Prosecutor A, loses after trial. The witness against defendant thereafter reaches out to Prosecutor B seeking a reduction in sentence for the loved one based on the testimony the witness gave. Prosecutor B initially says no, but after speaking with Prosecutor A, who prosecuted the defendant, agrees to a significant reduction in sentence for the witness's loved one. Neither Prosecutor A nor B say anything to the defendant about the agreement to reduce the loved one's sentence based on the testimony given against the defendant by the witness. Donald, I'm going to start with you first. Any issues?
As Giglio, as Brady has said, it really is not impacted. There's no evidence that there was any pre-arranged agreement.
Okay.
It seems that in the scenario that came only later by the witness, that witness's approach. But when we look at the basis of our constitutional protections and fundamental fairness, it does appear that witness may have been motivated, other than one's social duties or honesty, to testify against the defendant in scenario A, defendant A, when it appears that that witness then went to the prosecutor's office and said, look what I did in A, it should benefit the defendant in B, a relative of mine. Whether the prosecutor knew about it or should have known about it, it definitely raises some serious questions about the fairness of the process as it relates to that defendant A.
Let's talk about the issue of, is there a legal duty in Florida for the prosecutor A to know about the fact that the witness's loved one had been prosecuted by that office and could legally move to reduce their sentence? Should she have disclosed that, she or he, the prosecutor, disclosed that to the defendant?
Now, let's make sure you're talking about prosecutor A should you ask the question, should prosecutor A have provided information to the defendant, or the one that's been convicted, based on the testimony of the witness who now seeks some type of dispensation or, a benefit for her loved one?
Let me rephrase this. Should the prosecutor A have told, right when the trial was pending, or during trial, at any time before trial, hey, by the way, the witness against you has a loved one who we prosecuted and may move to have their sentence reduced at some point?
Oh, that's an interesting question. Are they compelled to?
Brooke, you can jump in if you want.
Okay. My position is yes. They would have a duty during the underlying trial, and we're talking about trial, not post-judgment. We're talking about during the trial. Does the prosecutor have a duty to disclose the fact that their primary witnesses have a loved one that is being prosecuted by the same office?
Had already been prosecuted, convicted, but could legally move timely to have their sentence, their significant sentence reduced?
That's a tighter issue. Because obviously now we're in the realm of speculating, right? Now the person has already been prosecuted. There is a sentence. There's a judgment sentence that has been rendered. So in that specific fact scenario, I say that's tougher. Now I will say that, however, in this context, many of the prosecuting units or prosecuting offices are addressing, I think, in the context of the integrity units and so forth, this concept of fundamental fairness that my colleague had already referenced. So even if it is a tighter legal issue as to whether there is a duty to disclose, because many of the offices are incorporating the integrity unit, if we can establish through an analysis of the entire record that the parents of the witnesses' testimony may have been tainted or biased as a result of their anticipation of a reduced sentence for their loved one, and if there is no other evidence against the accused, then it certainly opens the door, I would say, to a discussion about what should happen in that defendant's case.
Okay, so based on this fact pattern, Brooke, as an appellate attorney, remember the fact pattern includes the loved one receiving a reduction after trial. Okay, because again, I guess adding this, the loved one is still at the time of trial legally able to move for a reduction, even after trial, right? So I'm asking, would you advocate or would you raise that as an issue, even though maybe there's no clear-cut legal duty for them to have to say?
I probably would.
Okay.
Because in post-conviction litigation, and that's under Florida Rule 3.850, we often have to be incredibly creative with our claims. And I would probably raise that as an issue, and then conjoin that with a claim of newly discovered evidence in reference to the reduced plea. But there are complications with doing that. I mean, post-conviction litigation is incredibly difficult. The burden is very, very high, and the burden is exclusively on the defendant. And the problem with newly discovered evidence is that it generally cannot be that type of evidence that's related exclusively to impeachment, contrary to Brady. So I would probably combine the two, both under Brady's obligation to disclose potentially favorable information, and that relates to bias or reasons to doubt the witness's credibility, and that, of course, relates to the loved one conviction that's still under potential review, and the newly discovered evidence of the fact that the witnesses did in fact seek a reduced sentence and obtained that reduced sentence.
Okay, so I'm gonna play devil's advocate. So I'm prosecutor A, and I'm gonna argue that, listen, I didn't have an obligation prior to trial. I didn't even know or not as far as the obligation regarding the Brady. I didn't know that my witness had a loved one who had been received a significant sentence in this jurisdiction. I didn't know that. How can I tell the defendant that? Something that I don't know. And any of you can
Brady
jump
does
in.
not relate to an intentional withholding of information. It certainly can, but it doesn't have to. The state is presumed to have knowledge that is in all other state entities. And the fact that this individual was prosecuted by the exact same office, and obviously you're going to want to look at the timing. You're going to want to look at the connection of the divisions, whether it was even reasonable for the prosecutor to know. You're going to want to know all of those factual details. But the individual prosecutor's lack of knowledge would not necessarily be a defeat to Brady.
Okay, and I'm going to ask both of you this question. Do you both agree that the prosecutor can argue, I didn't have a duty to say anything prior to trial about, well, actually, they wouldn't be able to, because let's say they contemplated agreeing to the reduction after trial, and certainly they wouldn't have been able to know that because it was done after trial. Do you guys agree that some might argue legally there's no Brady violation because it was done after trial?
I do. I think that is a potential argument. Like I said, I think it's tighter here because we're dealing with a conviction that was already in play during the underlying trial. Had this been a circumstance where the individual was being prosecuted at the same time, I think you have a much stronger legal argument. As I said, a lot of post-conviction litigation includes an incredible degree of creativity. So the quick answer is yes, I would agree with that.
For due process purposes, even though there's not a clear-cut rule that says after trial, if something like this happens, there's a Brady violation, do you think that the Brady rule should maybe be extended to include any deals that are done after, or not deals rather, but any benefits given to a loved one of a witness that the defendant didn't know anything about? Do you think that the prosecutor, after they do that, after trial, should notify the defense or the defendant so that they can seek whatever post-conviction relief based on that issue? Do you think that should be a rule?
I don't know that I would advocate for that as a per se rule, in part because remember what we have to establish for post-conviction. You have to establish some degree of prejudice, actually a large degree of prejudice. And certainly had the information that we've been provided, had it also indicated that maybe the parents or the witnesses are now vacillating a little bit on their testimony, saying that maybe what they said was not entirely accurate, that certainly would invoke an obligation from the prosecution. But if it doesn't come with any of that, right? If the witnesses are still standing by their original testimony and saying, listen, I testified truthfully in front of the jury, I did what I was supposed to do, and I'm simply asking for a benefit for doing what I was supposed to do anyway, then it may be difficult to establish prejudice. I mean, that's the other prong that we haven't yet talked about.
But do you think that, but still, don't you think the defendant should get an opportunity to have the court decide whether they should get a new trial in order to once they learned of all of this, to be able to cross-examine on that in a new trial?
As a defense attorney, I certainly do. And simply from an individual perspective or even a moral perspective, I certainly do. However, when we're talking about post-conviction law at the state and federal level, that could be a slippery slope. And what are we doing with that? What obligations are we imposing, and how far are we going to stretch that?
Donald, go.
Well, what Brooke is talking about is post-conviction. What I'm really want to come from is a prevention having to get there. This witness may have had an ulterior motive, and I think that the prosecutor, now understand when it comes to criminal law, any sort of ifs or buts about things inures to the benefit of a defendant. So when we talk about Brady material, Giglio material, if there's some question about whether it should or shouldn't, the fact that there is a question of whether you should or shouldn't, you should always disclose. I think in this scenario that they should have said, just want to let you know that this witness has a loved one that has been convicted and has been sentenced to prison. At least then you have an opportunity at the trial during the real live fact scenario that you can put together so people like Brooke can deal with it, because without us putting the pieces together, Brooke doesn't have a whole lot to work with. So at least then we can start cross-examining this witness and say, hey, witness, understand that you have a loved one that's facing prison time. Are you looking by your testimony to get some type of favorable treatment? And if that witness says yes, at least that allows the jury to determine the weight of that witness's now testimony, knowing that there is some other motive other than just honest testimony.
So do you think it should be a rule that under this specific fact pattern, after trial, prosecutor agrees to reward a witness's loved one with a significant reduction in sentence? Do you think that the prosecution should alert the defense of that happening?
And that's directed towards me.
Yes.
Okay. I think an interpretation of the current rule probably does apply to the scenario you've given. I believe Brady was implicated with this witness who had a loved one who had significant prison time already on their shoulder, his or her shoulder. So I think that the state should have said, just to let you know, this individual may come with a certain amount of baggage that may affect their honesty. The fact that they have a loved one that was prosecuted from our office who is now going to testify against your client. So I think Brady says they should have let us know.
You agree with that, Brooke?
And I do. I indicated that I think that this argument needs to be made, and I think that it's certainly not a frivolous argument. It is a strong argument. Simply, though, under the context of where we are in post-conviction litigation, and the status of the law is not as favorable, which is why I would indicate that this is one of those creative arms that we often attempt in post-conviction. So is the argument there? 100%, and it's coupled with the fact that they did, in fact, seek a reduced sentence. That's why I said I would combine the two. Because the fact that they did act in that way, and the prosecution did, in fact, agree to reduce the sentence, that sort of bolsters the overall credibility of the Brady claim. So I think they work together hand in hand.
Okay.
So do you understand what I mean?
I do, Brooke. And so I want both of you to speak on this. And you can start, Brooke, since you do a lot of appeals. Does the defendant, he or she, automatically win just if there's a Brady violation seen?
Never.
Okay, is there another analysis that goes after that? Let's say an appellate court, or while it's under post-conviction review, decides, you know what, yeah, that's a Brady violation. Is there any other analysis that's done?
Yes, it's the standard Strickland analysis, Strickland v. Washington. You have to establish both error and prejudice. So you would have to establish that the nature of the Brady violation, whatever that evidence is, would likely change the outcome of the case. So in this instance, if the Brady allegation relates to evidence that would relate to the witness credibility,
right,
you would have to analyze the entire record to determine whether there's any evidence other than this witness testimony that would likely support the verdict. If this is essentially a credibility contest, meaning there really is no other evidence other than the witnesses who have the loved one that's being prosecuted, you would have a much stronger chance of establishing prejudice here. Because certainly if the jury disregards that testimony, if that means there's an acquittal, then you may reach the level of prejudice necessary to establish the post-conviction claim, but you must establish prejudice.
Donald?
Well, in a nutshell, what the appellate courts does is they'll say, let's take that piece of information out that is offended. Pull it aside. Look at the rest of the evidence. Does the evidence support a conviction? If it's clear and convincing evidence that evidence without that testimony would have still led to a conviction, you're dead in the water. Your argument is done. On the other hand, if that piece of evidence is so significant and so weighty in the determination, you pull that out and you look at the remaining facts and think, oh, doesn't seem like there's anything else left, then that is a significant piece of information, and that's what it's basically the harmless error doctrine. If there was a mistake, as the courts have said, everyone's entitled to a fair trial, but no one's entitled to a trial free from all error, just the harmless error. If this mistake, if you will, this oversight, this whatever you want to phrase it, had really no effect on the outcome, then it's still, no harm, no foul, so.
Donald, thank you so much for joining me today. You want to give your information out to anybody that might be needing any legal services in the future? Go ahead.
If you get arrested, call Haiti, call Donald.
No.
Just call a criminal defense attorney.
Where can they reach you?
My phone number is 813-376-8949.
Brooke, also thank you for joining me and Donald today, this afternoon, to discuss this very important issue. And can you please give the viewers the information where they can contact you if they need any type of criminal defense work or appeal?
Sure, absolutely, and thank you for having me. It's been a pleasure. You can call me at 727-543-7188.
Haiti Oropesa for Florida U Judge. Thanks for tuning in. Till next time.